The Garis and Neville Jeffress Pidler Proprietary Limited was a 1990 case taking place in the federal court before Justice Beaumont. This case was a significant decision in the spectrum of copyright. It gave particularly insightful guidance on why fair dealing defences cannot be relied on when copying. The matter related to fair dealing. Fair dealing is an aspect of Australian copyright law which allows materials to be copied without permission for certain purposes. There are 4 key provisions relating to the Fair Dealing in Copyright Act. They include research or study, criticism or review, parody or satire, reporting news. The applicants, Garis and Moore, were both journalists whose work had been published in the Western Australian and the Sydney Morning Herald. The respondent was Neville Jeffress Pidler, or NJP, a media monitoring company. The nature of NJP's business model was scrutinising various newspapers and media outlets to provide a photocopy of relevant subject matter to a subscriber in return for payment. The key question was whether NJP had infringed copyright through the exercise of their business of being a press clipping service. Garis and Moore argued that they were the author and owner of the literary work, and that NJP had infringed copyright by reproducing the work. NJP denied that copyright had been infringed on the basis of fair dealing. In particular, NJP contended that the reproduction was for research or study pursuant to Section 40, that the reproduction was for criticism or review pursuant to Section 41, and the reproduction was for the purpose of reporting of news in a newspaper, per Section 42, subsection 1. In considering whether the research exception applied, His Honour considered the ordinary meaning as stated in the Macquarie Dictionary, defining it as diligent and systematic inquiry or investigation into a subject in order to discover the facts or principles. His Honour determined that NJP did not reproduce a work for research, because the purpose was purely commercial. The intention was to provide a photocopy for payment. Relevantly, His Honour highlighted that to make out a defence of research, it must be NJP's purpose, not its customers. His Honour applied a similar process to the concept of study to conclude that Section 40 was not an available defence. His Honour considered criticism and review to fail as a defence as well, as the NJP merely photocopied the literary pieces without input or contribution. The photocopied clippings were not excluded for the purpose of reporting news because even though news can go beyond current events, which was established in Commonwealth of Australia and John Fairfax, NJP still had to prove that the copying was done for the purpose of or the association with the reporting of news. His Honour determined that NJP failed to establish the dealing as fair because the whole of the work was taken and supplied to the customers for their own reward and with no benefits to Garis or Moore. The outcome was that Neville Jeffress Pidler Proprietary Limited was ordered not to reproduce the work from either of the applicants. The outcome has had significant impacts upon copyright law, particularly by providing a definitive scope to fair dealing defences and when it may effectively be relied on in Australian law.